Welcome to the Supreme Court Podcast. All opinions expressed in this podcast do not reflect the views of the Supreme Court. For clarity, the text of the decision prevails.
In the Philippines, three extraordinary writs stand as protective remedies to safeguard the fundamental rights of the people: the Writ of Amparo, the Writ of Habeas Data, and the Writ of Kalikasan. In last week's episode, we delve into the Writ of Amparo, a powerful legal remedy crafted by the Supreme Court in 2007 to protect the right to life, liberty, and security, at a time when cases of extrajudicial killings and enforced disappearances had become a growing national and global concern. This week, the Writ of Habeas Data and the Writ of Kalikasan take center stage. Promulgated by the Supreme Court on January 22, 2008, the Writ of Habeas Data is both an independent remedy to enforce the right to informational privacy and the complementary right to truth, as well as an additional remedy to protect the right to life, liberty, and security of a person. On the other hand, the Writ of Kalikasan is provided for under the Rules of Procedure for Environmental Cases, which was approved by the Supreme Court on April 13, 2010. It is a remedy available to anyone whose constitutional right to a balanced and healthful ecology is violated or threatened. What key principles should we understand about the Writ of Habeas Data and the Writ of Kalikasan? How do these writs work in practice? And why were they introduced in the Philippine legal system? How do they empower citizens to assert their rights in the face of modern challenges, whether in the digital landscape or in the protection of our environment? Hi, I'm Attorney Mike Navallo, Supreme Court Chief Communications Officer. It's the 26th of September 2025. Today we talk about the Writ of Habeas Data and the Writ of Kalikasan, two more protective legal remedies which, together with the Writ of Amparo, complete the three extraordinary writs forming part of the legacy of the Supreme Court under Chief Justice Reynato S. Puno. And back with us to discuss these writs is Dean Tranquil Gervacio S. Salvador III, Dean of the School of Law and Jurisprudence of the Manila Adventist College and Professorial Lecturer of the Philippine Judicial Academy. Hi, Dean Tranquil. Welcome back to the Supreme Court Podcast.
Thank you, Attorney Mike. Thank you for the chance to be with you once more.
Yes, it's good to have you back, Dean. Now, picking up from our discussion last week, could you kindly briefly remind us why the Supreme Court introduced the writs of Habeas Data and Kalikasan following the Writ of Amparo?
I think it would be best for us to give them some sort of a chronology. Chronology of events. The Writ of Amparo was passed sometime in 2007.
Yes.
Then the succeeding year, the Writ of Habeas Data. If I am not mistaken, that was around January of 2008. And the Writ of Kalikasan, together with the bundle of environmental rules that was passed sometime in 2010. So it was at the time, if you would recall, in our history, in 2007, where there were a lot of news about disappearances, extrajudicial killings. And that I try to remember now that the Supreme Court wanted to address these constitutional rights that are violated. And for that reason, they passed the Writ of Amparo and the Writ of Habeas Data. And before I continue further, kindly take note that for those of you who will read the Writ of Amparo rules and the Writ of Habeas Data, it would somehow mirror each other. Like, for instance, if you will say the writ of, what is the Writ of Amparo? The Writ of Amparo is a remedy available for violation or threat of what? Life, liberty, and security.
Yes.
Okay? So it's not only a violation or threat. That's the Writ of Amparo. By reason of unlawful act of a public officer, public entity, or a private individual or entity. Now, take note of that. If you get to read the rules of the Writ of Habeas Data, you would know that it's more or less the same definition with an addition that the Writ of Habeas Data affects what? Those who violate or threaten to violate the right to privacy of individuals in terms of gathering, collecting, storing of data or information. And the data collected would pertain to person, family, home, and correspondence of an aggrieved party.
So there's a specific aspect, not just about right to life, liberty, and security in general, but the informational aspect to that, Dean. Why is it so sacred the right to privacy, that there's a specific writ for that.
The right to privacy is so important because that goes with our right to life. And just to give you an idea of a little bit of history about the Writ of Habeas Data, it was something that was it is an idea, constitutional right, formulated sometime in the 1980s in the Constitution of Brazil. So it was at the time that it was formulated, and the rest of the Latin American countries followed suit. If you would recall back to our history, you would note that at the time, the Latin American countries had a lot of military juntas. So not only should you protect the life, liberty, and property, but likewise the privacy of every man. Because as we say under common law, that your home is your castle. It's something that could be protected. It's something that cannot be infringed or violated. And it will be interesting to note that you could find some roots in the Talmud and even the Code of Hammurabi. And you will find also some roots from the Constitution, Malolo's Constitution, wherein it mentions specifically that the right of a Filipino, together with a foreign individual in the Philippines, cannot be violated. The right to privacy and the security of his home cannot be violated. So you cannot just enter a home unless there's earthquake, calamity, and there's need to protect that individual. So you would see how it actually evolved to what it is today. But you will not find the Writ of Habeas Data as a phrase, as a constitutional right. But you would see that it is clearly embedded in
several of the rights.
Yes, in Article 3 specifically of the Constitution, where we are given the power under the Constitution to be secured in our homes. And the privacy does not limit itself, and the protection is not limited to our life and liberty, but likewise to the right to live, which is to have a decent life, protecting our information, our reputation, and our honor.
And just a very practical question, Dean. How would we concretize when we talk about right to privacy?
Yes.
What manifestations can we mention, perhaps? In what forms do they manifest?
It's a very good question, especially now at the information age, where everything is available.
Right.
In fact, everything is available online. You take a picture, you upload it. You give information in a commercial transaction, it's readily available. You give your data, personal data, probably in a transaction or in a purchase. All of this are information that would have to be protected. And if I can go back to probably 30 years ago when I was a new lawyer, information is money. Information is value. And that was at that time when there is yet there was limited awareness of the right to protect this information. They pass on information of individuals. That's why you get to receive all of these calls and information.
Yes.
Everyone's
Even
selling you up to now. That's how vital information is.
So, technically, Dean, if there are individuals, the government included, who are able to take hold of our information, like when we receive messages now inviting us to apply for a job, technically you can resort to this remedy.
If there is a violation of your right to information or the right to informational privacy in that sense.
And what sort of remedies can you actually ask for under the writ?
What you could ask for under the writ would be to correct the data, to delete data, the manner of its storage. All of these are available in the Writ of Habeas Data.
Because it's not just about informational privacy.
Correct.
But there's also one aspect to this, the right to truth. Can you briefly discuss what this right to truth under this writ means?
The right to truth should be read together with other probably jurisprudence. All of us would say the right to information, right? Even government activities, even properties owned or assets, for example, of a public officer. We would say we have the right to information, if you would recall. But if you would note, there is also a very controversial discussion, which is a mandate for our public officers, SALN.
Yes.
Statement of Assets, Liability, and Net Worth. That issue was first confronted in the case of Morfe versus Motok, wherein the right to such information was questioned in relation to the anti-graft law.
Yes.
Wherein the Supreme Court sustained that there are as much as we have the right to privacy, there are certain limitations to our right to privacy. In that case, it was recognized that public officers would need to disclose such information.
In its present form, Dean, who can file? Is this similar to the writ of amparo, which we discussed last week, that anybody can file, technically?
Yes. That's a good question. As I said, somehow, especially for those who are studying the law, you look at both rules, it mirrors. It's not identical.
Yes.
I will share you why.
No.
Because in the writ of habeas data, you would see here that an aggrieved party may file the petition.
Yes.
Knowing that he's alive, he could exercise his rights. However, in cases of extrajudicial killings and enforced disappearances, there are individuals who could file it. Not the aggrieved party, because actually he's already missing or probably has already been killed. So this is the order of the individuals who could institute the action for him or her. Number one, any member of his immediate family of the aggrieved party, namely the spouse, children, and parents. And B, the ascendants, meaning the second layer, any ascendant, descendant, or collateral relative of the aggrieved party within the fourth civil degree of consanguinity or affinity. In default of the preceding, then only this will happen. One interesting matter that you will note, in writ of amparo, concerned groups,
Yes.
organizations, institutions, religious institutions can commence. But here, no.
So that's the difference.
Yes, you would note the difference. And the manner by which you could apply for it, unlike in writ of amparo, you would note that all of this, the order, as I mentioned last time, also applies to extrajudicial killings and enforced disappearances. But here, immediately there's a qualification. First, it's the aggrieved party. If the aggrieved party probably is dead or has disappeared, the following individuals can file it for him. So that's just a little bit of the tweak.
And implied is that this writ isn't just confined to extrajudicial killings and enforced disappearances, right?
Yes, that's right.
Because there's a separate portion for them.
And if you will allow me to further explain
please
this,
go ahead.
there was this idea before when this was the writ of amparo was passed in 2007, and subsequently the writ of habeas data was passed in 2008. There was this notion that it should always be a combination of this.
Yes.
There was this notion that it was always a combination, that the writ of habeas data was a complement of, complementary, or ancillary to the writ of amparo. Because the thinking always was extrajudicial killing and forced disappearances. But somehow, the Supreme Court has explained that this could be together with the writ of amparo and this could stand alone.
And speaking of the two writs, there was actually a case that came before the Supreme Court where the Supreme Court issued both the writ of amparo and the writ of habeas data. And this is the case of the environmental activists Janila Castro and Jed Tamano. They were supposedly reported to have surrendered to the military.
Yes.
But during the press conference, they turned around. They said, no, we were actually abducted.
Correct.
Now, we won't be able to discuss the merits, Dean, because I understand there is an appeal pending before the Supreme Court. But I would just want to ask, why the resort to writ of amparo and the writ of habeas data was actually resorted to by the petitioners here?
Okay. Just to give them the factual circumstances of the case, they were actually abducted. They were abducted, the two of them. These are advocates for the marginalized individuals and families around the Manila Bay Area.
Yes.
So they were abducted, and initially there was a question on who abducted them. But eventually they were brought to the camp, a battalion, if I'm not mistaken, the 70th Battalion, wherein it was now clear to them that it was the military establishment. So there, at that point in time, they were asked to tell a story, which is consistent with the story of the military, wherein they will have to tell the public that they are rebels and that they surrendered to the government. But there, at that very moment, they changed. They did not follow the story of the military.
Right.
They said we were abducted, and for this several days we were violated. So for that reason, they filed a writ of amparo. If you would note, there was already not only a threat but an actual violation. So here they could not file. Their relatives will have to file. Their parents will have to file. Now, so there is already an actual violation. Now, there is also the matter of the writ of habeas data. There is a need to do this because of the data relative to them, meaning where they stay, who they are, residents, relatives, activities. Because if I'm not mistaken, some of their personal belongings, bags, including telephones, were taken also.
So that's why. So we can see in those cases, you apply for both.
Yes.
But it's also possible to just apply for one
Yes,
without
writ
the
of
other.
amparo. Yes.
All right. So that's very clear, Dean. Thank you so much for that clarification. And how is that relevant in today's age, Dean? I know you touched on this earlier when we talked about the emerging concerns, but especially now when there could be surveillance done by big tech companies operating social media. They look at our preferences in terms of ads, right?
Algorithms.
Or algorithms, right? And there are also cases of online harassment,
Correct.
right? And data misuse. So how significant is the writ of habeas data now?
Well, if that is a standalone remedy, if you would note, you will be able to use that to correct a data, to have it deleted probably online. You've seen of recent cases, I won't mention them because some of
Yes.
them may be pending,
Yes.
that attributes probably a killing to a person,
Yes.
an abduction, a kidnapping publicly. So you cannot just let it be. So because the very moment it's online, it has been floating around.
Yes.
So you would need a remedy, some sort of a remedial measure to be able to have it deleted, corrected, changed. Then you may apply for the writ of habeas data.
Okay, Dean, now we go to the next writ, the writ of Kalikasan. So, while the writ of habeas data focuses on protecting individuals, the writ of Kalikasan extends this protection to communities and the environment. Could you enlighten us what the writ of Kalikasan is and why was it introduced?
Okay, allow me first to explain what the writ is about.
Yes.
The writ is a remedy available to a natural person, a juridical entity, or an entity authorized by law. And this will be interesting. People's organization can seek this as a remedy. Non-governmental organization or public interest group, okay, accredited by or registered with any government agency. Now, why will they even apply for this writ? Okay, the writ is necessary for the protection of constitutional right to a balanced and healthful ecology. And kindly take note, it is not only violation, but includes threatened violation. Take note of that. Not only violation, but threatened violation. And this pertains to an unlawful act or omission of a public official or employee or a private individual or entity. And my next line will be very important, especially for those who actually take the bar exams, because the environmental damage should be of such magnitude as to prejudice life, health, and property of inhabitants in two or more cities or provinces.
That's an important
Yes,
element.
that's very important. And this has been asked in several bar exams.
Yes.
So a law student will have to remember this, that the extent of environmental damage is of such magnitude as to prejudice the life, health, or property of inhabitants in two or more cities or provinces. Because if it does not affect two or more cities or provinces, file a citizen suit.
That's the difference.
Yes, file a citizen suit.
I'm wondering what's the logic behind that. Is it
This
because
one?
of the magnitude, the
Yes.
scale?
Yes, because of the scale of damage that it could result to a community. And the importance is so evident that it could only be initiated with the Supreme Court or any divisions of the Court of Appeals.
So there's no concurrent jurisdiction
Yes,
here.
yeah.
There's
Concurrent
concurrent
ju-
between
but
Supreme Court and CA,
Court of Appeals.
but no RTC.
Yes. Unlike the continuing mandamus, which could be applied for in the RTC, Court of Appeals, and Supreme Court. Yes.
So, well, kind of makes sense because if there are two cities or provinces involved, you can't just choose possibly where to go, right? Which
Yeah.
RTC.
Yes.
So that's why you go to the CA and the Supreme Court.
And you show how important it is. And the damage may not even be limited to just two cities or provinces, because there will be cases that you will find that it might go to two or three provinces.
And what are the consequences, Dean, of the issuance of the writ of Kalikasan?
Okay.
To whom is it issued against?
The writ of would be those that violate or would threaten to violate. So what you're trying to tell them is you should stop, cease and desist from committing environmental violations or violating environmental law. So the environmental law, rule, or regulation violated must therefore be alleged in the petition. And the facts and circumstances resulting to that violation should also be alleged in the petition.
And there's one interesting case here, Dean, and later on I will ask about this requirement that it should be between two provinces or cities.
Yes.
This case of the West Tower condominium, where there was an oil leak sometime in 2010 in Makati. So there was a writ of Kalikasan issued here. What prompted the Supreme Court to issue a writ of Kalikasan?
I think it would be best to give them some sort of the facts.
Yes.
Because based on our discussion, it should affect two or more cities or provinces. But here, the West Tower was located in Bangkal, Makati. And it was a leak. Okay, it was a leak that initially a few drums only that ran to around, actually probably around more than 10 drums to 15 drums of fuel. Now, let me explain this to you. There were two pipelines operated by the first Philippine Industrial Corporation. Okay? And the first one is what you call the white oil pipeline system, which covers the area of 117 kilometer from Batangas to the Pandacan terminal in Manila. So you would notice 117 kilometers. And that pipeline would transport diesel, gasoline, jet fuel, and kerosene. And another line is black oil pipeline. Okay, that would which extends to 105 kilometers and transports bunker fuel from Batangas to the depot in Sucat, Parañaque. Okay, this system transport nearly 60% of the petroleum requirements of Metro Manila and parts of the provinces of Bulacan, Laguna, and Rizal. So therefore, the actual damage may be in, right? The actual violation may be in Bangkal, Makati. But the truth is, the threatened violation could be far greater. Correct?
And we should note that this was not actually touched on in the case, this aspect. So it was sort of assumed that this already applies to writ of Kalikasan.
Because I would think that no one made an issue out of it.
Yes.
It was already a clear understanding among the parties that this is a case subject of the writ of Kalikasan.
And what about the case that made it a perfect subject of the issuance of the writ of Kalikasan?
The damage to the community was the fume. The fume. And because of the fume, as a result of the leak, the residents of the West Tower in Bangkal, that's a condominium, were forced to evacuate. And until it was restored to a condition wherein they could reside, they could live at peace, and the conditions are good, then they will not be allowed to return. And that is the reason why there was here, if you would note, in a writ of Kalikasan, you would be required to cease from violating. If you are violating, okay? Cease or desist. Now, once the violation is identified and the Supreme Court would like you to correct it, the Supreme Court may even require you to restore it in the same condition as it was, to rehabilitate it, to correct it, okay? The violation. Now, after having said that, the Supreme Court, the beauty of the environmental rules that the Supreme Court passed is that the Supreme Court can require the performance and monitor. And monitor whether you were compliant with the order of the court.
Interesting.
That's the beauty of this writ. That the Supreme Court can monitor it. And the Supreme Court can even require you to report based on the decision of the court. Ganon. That's how it is really for the protection of our environment, for a balanced and healthful ecology.
In a sense, there's this continuing requirement that until you comply with the court's order, you should observe at least measures to mitigate this. So this is very interesting, and this is different from the continuing mandamus, right?
Although in continuing mandamus, you would, it's also an environmental rule, but you are required to perform. And the performance is not limited only to one act, okay? Because there's a law that requires you to perform, but it's a continuing mandate from the court to do it. To do it and to see to it that you act in compliance with environmental laws.
Right. And does the filing of a petition for the issuance of a writ of kalikasan bar any other remedies that might be available?
Not necessarily.
Damages.
Not necessarily.
So you can still file.
Yeah, you could file the necessary actions to be able to, for example, you have suffered so much damages. So you recover from those corporations. You file a civil action. If there are criminal acts that may have been violated, you file the criminal action, or probably an administrative case if necessary.
And here's an interesting question, Dean, that we discussed amongst ourselves when preparing for this podcast episode. The writ of kalikasan is not like an environmental clearance, right? It is a remedy that you go to court, not to an agency. But in case the DNR has actually given you an environmental clearance, for example, if West Tower was given environmental clearance, does that bar the filing of a writ of
I like that
kalikasan?
question. I like that question because I did some of this application for environmental compliance certificate
Yes.
as a young lawyer. And that's why I know that there is a need probably for a construction, for any activity for that matter, to get an environmental compliance certificate.
Yes.
And it does not necessarily mean that if you get an environmental compliance certificate, the writ of kalikasan cannot be instituted. Besides, there are conditions in that clearance,
Yes.
in that compliance certificate. The very moment you violate the same, you could even be subject of cancellation of that certificate.
Right.
And the proper actions could be instituted against you.
So you cannot use the fact that the DNR gave you that environmental compliance certificate to say that you inspected this. You should have known. You should have seen the
And I think
conditions.
every one of us lawyers would know that estoppel does not stand against
Exactly.
government.
Right. So just an interesting thought
Yes.
to this discussion, Dean. And maybe perhaps to close our discussion
Yes,
today, we
please.
talk about two writs, writ of habeas data and writ of kalikasan. Perhaps what's our takeaway for our listeners? What should we keep in mind?
I think what we have to keep in mind would be to have our citizenry educated. Because these rules are very good. But unless they know this, they cannot apply for this. They cannot seek refuge from these rules. So it would be best that there be education, and everyone in the community should participate in the education. It's not only the duty of schools, but also the society and the community, that they know what their rights are, and so that they know how to protect themselves. Because the rules will always be there. The Supreme Court can always, in the exercise of its rulemaking power to protect our rights, will pass good rules. But if we are not aware of it, and those that would enforce it or would have educated it, would have passed on activities to educate the public, would not do their task, then all of this would be useless.
Right. So it's useless if nobody uses the law,
Yes.
the rules, for that matter. And then thank you very much again, Dean Tranquil, for joining us today. We hope to have you on board again sometime in the future.
Thank you.
All right,
Turn the
Dean.
mic.
And if you wish to read the full text of the rule on the writ of habeas data and the rules of procedure for environmental cases, please visit the Supreme Court website. Here's Steve Atendido Beltran, Supreme Court Information Officer, for this week's updates.
From the Supreme Court of the Philippines, here's the latest. On September 22 to 26, 2025, the Supreme Court of the Philippines hosted a study visit by a delegation from the Federal Court of Australia, or FCA. The delegation was led by FCA Chief Justice Deborah Sue Mortimer and included Justices Stephen Burley, Sarah Darrington, and Thomas Michael Thawley. They were joined by FCA court officials, Senior National Judicial Registrar Mr. Paul Farrell, Acting Executive Director Corporate Strategy and Programs Mr. Jimmy Mastorakos, Acting Chief Information and Digital Officer Mr. Nathan Price, and International Programs Manager Mr. Martin Clutterbuck. They were warmly welcomed by Acting Chief Justice Marvick MBF Leonen and Associate Justice Maria Filomena Singh, the chairperson of the Special Organizing Committee for the Federal Court of Australia visit. One of the highlights of the visit was a two-day Philippine Judiciary Knowledge Exchange held on Wednesday and Thursday at the Judicial Academy Philippines in Tagaytay City. Organized by the Philippine Judicial Academy, the exchange featured discussions on class actions, intellectual property, native title, and admiralty law. where resource persons from both the Philippine and Australia side shared their insights as to differences and commonalities between the two jurisdictions. More than 100 appellate court justices, trial judges, court personnel, practitioners, and members of the academe participated in the event, which sought to find areas for future collaboration. The Australian delegation also paid a courtesy call and held meetings with SC Associate Justices and court officials. FCA court officials held dialogues with the offices of the Regional Court Manager Regions 3 and 7 and visited the Lapu-Lapu City and the Tagaytay Halls of Justice. The FCA delegation also attended forums at the Philippine Competition Commission and the Ateneo Law School. The visit was sponsored by the SC, and Australian government supported Fostering Advancement of Inclusive and Rights-Based Justice or Fair Justice program, pursuant to the Memorandum of Understanding on Judicial Cooperation between the SC and the FCA, signed in May 2024. Meanwhile, the SC has ruled that the Construction Industry Arbitration Commission, or CIAC, has the authority to determine who should receive the judgment award it granted to a corporation that has already been dissolved. The SC Second Division, through the Ponencia of Associate Justice Josep Lopez, upheld CIAC's order directing Philippine Commercial and International Bank, or PCIB, now known as Banco de Oro Unibank Inc., or BDO, to pay individuals identified as stockholders or their heirs or representatives of the dissolved William Golanco Construction Corporation, or WGCC. The SC affirmed that under Executive Order Number 1008, or the Construction Industry Arbitration Law, CIAC has the authority to resolve disputes involving Philippine construction contracts when the parties have agreed to submit their case to arbitration. The revised rules of procedure governing construction arbitration also grants CIAC broad authority to issue orders necessary to enforce its awards, including identifying the individuals or entities entitled to receive them. Since WGCC's assets had already been distributed to its stockholders or their heirs, CIAC had the authority to determine the individuals who should receive the monetary award and how much each person should get. In another decision, the SC has reiterated that preventing employees from entering company premises and doing their jobs without a valid reason is considered illegal dismissal. In a decision written by Senior Associate Justice Marvick Leonin, the SC Second Division upheld the labor arbiter's ruling that 12 workers from Constant Packaging Corporation, a company that prints packaging materials, were illegally dismissed. Ruling in favor of the workers, the SC clarified that employees who are able and willing to work are considered illegally dismissed if they are prevented from entering the workplace without a valid or lawful reason. And because the workers were suddenly dismissed without following the required procedures, their dismissal was unlawful. The SC ordered Constant Packaging to pay the workers separation pay, back wages, service incentive leave, and holiday pay. However, since the workers were hired on a Pacquiao basis, the SC ruled that they are not entitled to 13th month pay. In another case, the SC has reiterated that banks may be held liable for moral damages suffered by depositors due to negligence, even if there is no proof of bad faith or malice. In a ponencia by Associate Justice Samuel Garlan, the SC's Third Division ordered Banco de Oro or BDO to pay Remedios and Angelita Antonino the proceeds of their time deposit, including 100,000 and moral damages. Ruling in favor of the Antoninos, the SC cited Section 9 of BDO's Terms and Conditions for time deposit placements, which requires the surrender of time deposit certificates when withdrawing deposits. Since the Antoninos still had the certificates, the SC concluded that the funds were not withdrawn. The SC noted that the PNP expert said the signature on the demand draft was likely forged. Immigration and passport records also showed Angelita could not have been in the country to sign the draft. BDO also failed to verify the identity of the person who withdrew the funds. The SC held that these lapses showed BDO's failure to exercise the required diligence, especially given the large amount involved. Meanwhile, on Thursday, September 25, Japanese Supreme Court Associate Justice Yasunami Ryosuke paid a courtesy visit to SC Associate Justices Ramon Paul Hernando, Josep Lopez, Jose Miras Marquez, and Antonio Coa Jr. at the Supreme Court in Manila. Joining them was Court Administrator Maria Teresa Gomez Estoesta. Justice Yasunami was joined by Director for International Affairs and Judge Takazukura Shinpei, Japanese Ambassador to the Philippines, His Excellency Endo Kazuya, and First Secretary Ms. Kimura Yayoi. The SC Justices discussed initiatives under the Strategic Plan for Judicial Innovations 2022 to 2027, such as improving access to justice through video conferencing hearings. You're now up to date with the Philippine Supreme Court. I am Tiffany Batran, Supreme Court Information Officer.
And that's our podcast this week. Join us again next time for a detailed discussion of select cases decided by the Supreme Court. I'm Attorney Mike Navallo, your Supreme Court Chief Communications Officer. You can catch this podcast on the Supreme Court Public Information Office's accounts on X, Facebook, Instagram, Threads, YouTube, and Spotify. You can also catch previous editions on our website and on Spotify. This podcast episode was produced by the Supreme Court Public Information Office with Attorney Karen Martinez, J. Rempilio, and May Sibal as researchers, Brian Ostrea, Don Ryan Balza, Victor Laranio, Lawrence Olanio, Austin Aliscad, and Bea Batung as audio and video editors, and Taik Flores and Jerome Batumalake as web editors.